Hello, I'm John Miller with Rock Solid Law, founding attorney, and this is our continuing series of webinars regarding subject matters that we think are important in real estate, estate planning, and also occasionally for small businesses in small business law. Today, we're really focusing in the real estate area, and glad that's of interest to you. For those of you that haven't been on one of these webinars with me before, there is a chat screen. It's about right there, and you are welcome to put questions in there, and I'll try to handle them as well as I can. If they're too fact specific, I may take it offline and communicate with you after the actual webinar. No question's a bad question except an unanswered question. So if you don't know me, I'm a 35-year lawyer who's practiced in real estate since the early 90s. And I am proud to say that my title claim record is clean. We've been with First American for a long, long time and have had no claims. So knock on wood, we continue to do that. So what I wanted to talk about today is what is the value in title insurance. It's a different kind of insurance. People really don't know what it is they're getting. And so importantly, at a closing, there are two different types of title that you may see. The one we're going to talk about less today is called a lender's or loan policy. That policy is in favor of the lender if there's one involved in the transaction, that's the bank, who is loaning the money for the mortgage. That policy will protect only the lender, and is in effect only as long as that loan is outstanding. So in the case of a refinance, obviously with a sale, that policy has lived out its full life and it is done. During the time it's in effect, it will protect that lender and ensure them fully in title to the property. We're going to talk a little bit more about what that means in the next probably 30 minutes. So the policy that we are focused on today is the owner's policy. So typically in our part of the state, the seller purchases an owner's policy for the buyer, and we will see that on the closing statement each time. Then the simultaneous issue policy is also issued to the lender. That's the loan policy I was talking about recently. Almost all lenders require certain endorsements. That's beyond the scope of today's webinar. But just if there are realtors on the line, and I believe there are, it'll help you to be familiar with those terms. Endorsements are compliant with Florida law, essentially, is what they're doing with that policy. So the maybe the best way to think about title insurance for the owner is that for most people, most Americans, the purchase of their home is their biggest investment, certainly their biggest first investment. Many people go on to invest in other things. Maybe they'll even spend more money than they do on their home. But the saying, our home is our castle, I like to say sand castle here in Florida, is very appropriate because particularly in 2020, we're spending a lot of time at home and our home is what is important to us. So we want to protect our home from outside legal claims, right? So the rule of thumb, for the cost of an owner's title policy is it's about 0.5%. That's a 0.5% of the purchase price. And that is going to ensure that that owner has good, fee simple, free and clear, marketable title throughout the time that they own that property. So if they own the property for the rest of their lives, if it is their forever home, then that single premium paid at closing provides coverage for the rest of their lives, right? So what happens is that a chain of title is pulled. We see very few people in fact, in the 35-year career, I've seen none in Northeast Florida who get their title directly from the Tamacoan Indians who were here when the Spanish came. guess actually the Huguenots from France got here first, but read your history, the Spanish won out in that battle. And so the King of Spain owned all of Florida. So we often talk about Spanish land grants. That's obviously the farthest back route of title. The Tamacuans did not have a system of private property ownership. So we joke about, I got my title from the original Spanish land grant, very unusual. Usually properties in Florida have passed hands, changed hands many, many times. So that chain of title will go back far enough to give us an idea of whether there are any outstanding liens that are recorded properly in the public records, which can be removed so that fee simple title can be sold. Now, a great example is a mortgage, right? So if the seller has a mortgage, that mortgage is going to be paid at closing, and that mortgage can be removed from a impugnment on the title. There's no longer a lien of the mortgage once it's paid off. A lot of times we'll see construction that started with a notice of commencement, and nobody thought to close it after the project was done. So one of the jobs a title lawyer and his team will take care of is going and finding that contractor and getting them to sign the proper documents to take care of that. There are any number of things which could show up on title which will be resolved at closing. There are also matters that are not on public record, and title insurance can insure you against those matters as well. This is why we do things like a municipal lien search. So those of you that have been on these calls before know I like to tell a story. And this one did not happen in my practice, but comes to me through my title underwriter. And is the story of a couple who purchased a home, and the seller took back financing. Of course, title insurance is not a requirement of a closing. But candidly, I don't do any without it. Why? Because the liability is too high. If we were to miss a lien, we would be the victim of the lawsuit that would come later when there was an adverse title claim. We're going to talk about some of the very many facts which can occur that may arise to this kind of claim. So this couple borrowed from their seller, paying $1,500 a month, and made their payments timely all the way up until they received a notice that their home was being foreclosed. And that was because the seller actually had a mortgage on the property that he did not disclose to this couple, and that he did not pay when he received their monthly payments. They had borrowed money from a lender. The lender had a loan policy, and therefore the lender was protected against this adverse claim. And in fact, after the foreclosure, the lender got paid. So the bank was made whole, but very sadly, the couple lost their home. And of course, everything they had invested in it. They would have the opportunity under our laws to sue the seller. But if you think about it, a seller who had run a scam like that is very likely to be judgment proof. So I would guess that there was no real relief available to them. Had they just purchased title insurance, the title insurance company would have made them whole, either by paying them out for their loss, or by perhaps defeating that lawsuit, maybe paying off the first mortgage so that they had free and clear title. Somehow they would make them whole. So big loss on their part. So there can be things like the title claim we just discussed, some lien sitting out there that we don't know about, or a bill left unpaid by the seller, like in the repair or renovation circumstance we just talked about. Maybe the seller had some work done to make that house saleable, but they didn't pay for it. What happens then? What happens then? Well, the buyer's got to pay off that to keep the lien off their property. So real quick, 10 very common title problems. Errors in public records. Yes, they are there. We found them ourselves. They're clerical errors. They're filing errors. People file in the wrong county. People have the wrong legal description, so it doesn't come up. So any of those kind of things that would come up after the purchaser gets their home are covered under the title insurance policy. Unknown liens. All right. So there we talked about that example a minute ago, a lien that was on the property that was not known. So if you have a title insurance policy, that lien's either going to be cured before sale, at sale, or the insurance will make sure that it gets cured later. Illegal deeds. We call them wild deeds. There are times when people file things on properties they don't have any claim to, but those deeds can cause someone else to buy the property and bring a claim against you. And it can be errors made in a prior closing, like a deed by an undocumented immigrant, a minor, a person of unsound mind, therefore not having legal capacity. And maybe somebody said they were single, but they were actually married. So in Florida, we have the homestead, so that spouse would have a claim. Missing heirs. Maybe missing heirs weren't included in a probate, and therefore an heir can come out of the woodwork and make a claim against your property. Forgeries. Y'all, fraud is out there. We're seeing it. We're stopping it left and right. If you get an email from me, you're going to see, or any member of my team, that we require that folks call us before we will do a wire. Why? We want to stop those fraudsters. They're out there and they're trying to steal from us. Real property is ripe for fraud, and therefore forgeries and fraud are something we really have to look out for. Undiscovered encumbrances. Maybe they gave an easement. Maybe they gave some sort of other restriction or covenant against the property, which precludes you from doing what you wanted to do when you bought it. Title insurance eliminates that as a potential downside. I just mentioned easements. Maybe that easement is so big that you can't build the house you wanted to build. It could be to a government agency, another business, or other parties. You know, every home needs ingress and egress. My personal home, in fact, has an easement over an adjoining property because the street that our home was on was never built in Jacksonville Beach. So we have to go across the neighboring property to get out to another street to have our ingress and egress. There could be boundary or survey disputes. Some regularly. Two surveyors will make a different finding. And if there's a survey dispute with a neighbor, that's something that you want to have insured as well. An undiscovered will. Maybe somebody dies and everybody says there wasn't a will, right? And so the probate might occur intestate, meaning without a will. And then the will comes to light. What if that meant somebody else actually has an ownership in the property? That's kind of a big one. False impersonation of the previous owner. I can tell you this is not as wild as it may seem. My practice many years ago includes a man bringing a woman to a closing. The woman somewhat resembled his wife, and he had his wife's photo ID, driver's license, and he tried to sell a piece of property using the imposter as the quote unquote wife. Fortunately, we caught it and stopped that fraud from happening. People will do stuff like this, guys. So we actually have, and we'd be glad to share it with anybody who wants to write me a pamphlet. Sorry, the real one's in color. The one I'm using is not. Color just distracts me. 70 ways you could lose your home and one way to protect it. I'm sure you know the one way to protect it, and that's with title insurance. Realtors, this is why title insurance is important. I had a realtor call me within the last quarter, 3 months, who asked me to do a closing without title insurance. And I said, I just won't do it. I'm not going to put my 35-year law license out there at risk by giving an opinion of title that it is good when it's not. So please, realtors, as you're at your next NEFAR event, your next open house, and talking about it, talk to the newbies about the importance of title insurance. It really, really is important. So there are too many of these to list them all. It would be really boring for you guys if I did, but I'm going to hit some of them. All right. So we've talked about some things like forged deeds, mortgages, satisfactions, or releases, right? Somebody could have forged the release or satisfaction, and therefore the lien remains on the property. A mentally incompetent person, a minor, right? That's anybody under the age of 18, 17 and under in Florida. A corporate deed where the person didn't have authorization to sign for the business entity. Same with a partnership, a trustee who wasn't actually the trustee of the trust. A deed to or from a corporation before they were actually formed or while they had expired. I'm dealing with that issue right now, trying to help a corporation get reformed so the property can be properly sold. A non-entity, like a club, a church, a charity, that isn't actually able to hold or transfer title. Person in a foreign country could be challenged as a defective under the foreign law. Use of an alias, incorrect name usage on the instruments. We talked about fraud, but there's also undue influence and duress. It happens a lot with elderly. This is a classic elder abuse situation. Man, deeds following foreclosures, watch out for them. I know people get rich doing real property out of deed sales or foreclosures, but they are fraught with landmines throughout. All sorts of judicial proceedings, bankruptcies, probate, conservatorships, and divorce. Got to be careful about deeds coming out of divorce. What's the status of the proceeding? Just skipping a few. No jurisdiction. Like if a court didn't have jurisdiction to do what they said they did. We have recently all become familiar, well, those that didn't know, become familiar with jurisdiction issues as our United States Supreme Court has recently declined to hear cases based upon that legal premise. Mistake. The grantor didn't know what they're doing. They thought they were signing a deed on something else. A falsified power of attorney, an expired power of attorney. Lots of litigation out there about powers of attorney. That's a tough one. Validly executed but delivered after the death of the grantor. That's not okay. The person who was holding the title as joint title or something like that and didn't get the other party to sign. An undisclosed divorce. Not joining all the heirs of a deceased person. There's lots and lots about heirs, survivors, and estate. Ooh, this is a yicky one. Conveyance by heir or survivor of a joint estate who murdered the decedent. That probably would be a good plot for a TV show. And it has to be done correctly when somebody is serving in the military. I'm actually doing one of those today with a power of attorney, and we had to get a single document to Japan because, believe it or not, he's got to declare that he's alive today, right, for us to be able to move forward. The lender requires that, and so we will get that document as part of our closing. Perhaps somebody else might not do that, and it could be a challenge to the transfer. Deed from the government can be challenged sometimes. Okay, we talked about ineffective release of a satisfied mortgage. Maybe that mortgage was sold before they released it. I think you're getting it. There's just all sorts of scaries out there. Ineffective release, disputed release, ineffective subordination agreement, a deed recorded not properly indexed to be locatable. Couldn't find it because the clerk screwed up, right? Undisclosed federal or state tax liens. That's a biggie. Got to find those. And municipal liens don't show up in the search. That's why we have to search Jacksonville and each of the beaches to find out if they have any liens out there. Prior mortgage, pending lawsuits, environmental liens, right of first refusal on the property or an option to purchase that wasn't disclosed and comes out later. So I think you're getting the message. All of these things are curable by simply having an owner's title policy. Here's a great one. Party walls, right? We have townhouses. Party wall agreements can mess things up. Errors in the tax records, those happen. Erroneous release of a tax lien, special assessments. That's a big one, guys, because there are homeowners associations a lot out there in Florida. Adverse claim of a vendor, adverse claim of equitable lien. That one's sort of so nebulous, it can come out of the woodwork at you. Misinterpretation of deed, will, other instrument. Lots of stuff about probate in here, which is a labyrinth. Not a landmine, not a quagmire, but a labyrinth. Why? You just have to know the path. And if people don't do it correctly, it can really mess it up. Yes, defective acknowledgement due to lack of authority of the notary. What if the notary had expired and nobody noticed it, but the stamp showed it was true? Forged notarization or witness acknowledgement. It's so important to have those witnesses and notaries sign right at the closing ceremony. Deed not properly recorded, wrong county, missing pages or other content. Don't you think in this era of electronic filing, those things happen with a page just getting out of order or something? So then you can get extended coverage for the following things. These aren't very many, so I'll go ahead and list those. That, of course, would be at an extra premium, but a deed to a purchaser from one who has previously sold or leased the same land to a third party under an unrecorded contract where the third party's in possession of the premises. Next, claimed preemptive rights, not of record and not disclosed by survey. Next, physical location of easement, maybe an underground pipe or sewer line which does not conform with the easement of record. I've seen those where the utilities actually don't go where they're supposed to go. The beaches started getting built out over 100 years ago. So there's stuff underground. I don't think anybody really knows where it is, right? Deed to land with improvements encroaching upon land of another, right? So that's the classic shed built across the property line. Back when I was a litigator, I litigated that one. Incorrect survey. Been working with one of those lately. It just had a note on it about a wall. It's actually a fence, or it was a fence that was actually a wall. I can't remember which. And whether or not that encroached on the property, we were able to resolve that favorably for the new title owner. A mechanic's lien. Some people call them contractors' liens, which you can only lien homestead certain ways, and those are the people that work on the home or people that loan money against the home, or taxes. IRS, state tax can attach. So those can attach without recorded notice. There is a recording statute as well. Federal estate tax or state inheritance tax may attach. Pre-existing violation of subdivision mapping laws. Pre-existing violation of zoning ordinances. Pre-existing violation of conditions, covenants, and restrictions affecting the land. So listen, there's all these things that can be wrong with title. And there's an easy fix. And that's what title insurance is all about, because it gives the new owner of the house peace of mind. So it's all about peace of mind. I don't claim ownership of this, but I love it. One of my good friends at First American Title came up with the following with regard to things that can be wrong with title and that title insurance covers. It might have been fraud, Maud. There was a lien, Gene. You don't own the land, Stan. Should have listened to me. The homeowner's due, Suze. The person was dead, Fred. What about the will, Bill? You should have listened to me. Imagine Paul Simon, 50 ways to leave your lovers. Looks like I might have a Yes, so I do have a question, which is shared walls in townhouses. Expand a little on how this issue comes up and a remedy for the issues. So usually there's a party wall agreement regarding the wall. And in my practice, it came up where someone attached something to the wall, which came across the line on the neighbor's side, right? Maybe siding that was wide, or I don't know, some sort of exterior box of some kind to do with a security system, those sorts of things. So um, there also is the possibility that as built, it doesn't actually conform to the easements granted by the party wall, so that there could be an issue between the neighbors where the townhouse as built actually infringes into owner A's property from owner B. It can be resolved with easements, but in my experience, people don't enjoy having to do that. And even in an instance I'm thinking of where a mutual easement was proposed to be granted, one of the parties absolutely refused to enter it with the neighbor. So I think as a general matter, that's as far as I want to go into that right now. But yes, there can be um, infringements for party walls. And of course, if that were to be the case, the title insurance policy would cover curing whatever it was, probably by means of proposing an easement, like I referenced. And failing that, there'd have to be a quiet title where the judge could take the equities into mind and make a new determination of the property rights. And of course, that would be paid for by the company issuing the title insurance policy. Hey, we're in the holidays. I hope everybody's having wonderful holy days with whatever your beliefs teach you. I am certainly enjoying mine with my family. As such, we are going to do a Zoom next Monday morning. I believe it's at 10 o'clock. And that's going to be a live presentation of estate planning in a changing world, which we gave live, of course, from the time we announced it to the time we held it. We'd had another spike with our pandemic. And while everybody who accepted came, it wasn't a huge crowd. And we did have a number of people request that we teach that live. So I'm looking forward to doing that at 10 o'clock on Monday. If you don't get an invitation, which you should, but if you don't, you'd like to attend, let me know. I'd also like to let you guys know that I am appearing on the Gary Thurman radio show on Tuesday morning at 10. So you'll get a notification of that too. You can access it online. I haven't done a lot of radio in my life. So as the old line goes, I've got a face built for radio, so I'm hoping it'll go well. And just by way of thanks for joining us during this Zoominar, I will offer each of you who are on the webinar this morning the opportunity to have the closing fee waived. Merely reference the title of this webinar, and my team will be glad to do that for you. So try us out for a closing. We enjoy the closing business as well as the estate planning and representing small business owners. So I did my best to advise you of the song by Paul Simon. So here's a little bit of it to take you out today. And remember, might have been fraud, Maud. There was a lien, Gene. You don't own the land, Stan. You should have listened to me. Homeowners dues, Suze. The person was dead, Fred. What about the will, Bill? You should have listened to me. Listen to me. Have wonderful holidays. We'll see you next time. John Miller, founding attorney, Rock Solid Law. So pleased to be with you.